PW10 है वो भी ये बताता है कि चने के खेत में पानी देने का कोई सीजन समय नहीं है। मतलब therefore the evidence of Kopiar has been used because he was an injured witness for convicting the appellant, especially my lord, when there are many accused persons. That finding is part of purpose. ये मेरा केस है.
So this you were released on temporary bail in the middle sometime.
That was for the purpose of arrest.
So had you surrendered?
That's all.
Yes, state council. For 10 days he was released for executing the sale deed, I think. That was on 10/1/23. इसमें रिकॉर्ड में होगा देखो सरेंडर जनवरी 23 के बाद में तो नहीं है. सरेंडर वो एक्चुअली बाद में लिया नहीं गया उस पॉइंट करा होगा सरेंडर करा होगा पता नहीं. Anybody else released on suspension? Not yet.
What is my lord? I just point out. Number 11.
ऑब्जेक्शन में आपके कोई एंटीसीडेंट्स हैं इनके? हाँ?
Yes, September.
How do you know?
I'm not the record man. The party papa.
Have you filed it?
I don't know what was charged.
आप फाइल कर दीजिए रिपोर्ट. Because it's a 13 years is a long period. So we lick that one of the major grounds on which the suspension of sentence is sought by the appellant number 3, Pyar Singh, that he has suffered more than 13 years of incarceration. There are two applications, and there are two applications for separate. Next, let the counsel for the state file the report regarding presence or absence of criminal antecedents on the appellant so and so and so. List in the week commencing 13th. On the week commencing 13th May. The state is also directed to file custody status report of both the appellants. So that comes with that details.
Number 43 is Patel.
Yes, yes. What is the default?
Number is to direct type of
80 और 81 देखना पेज.
डबल हो गया.
क्या चैलेंज किया आपने इसमें?
फर्स्ट सैंपल में हमारा एक कहना था जो आर्टिकल 1 और आवाज नहीं
हम्म।
और एक्सपर्ट की ऑप्शन में तो जो हमारा जॉब डिफेंस स्टेट में सेक्शन 45 का आवेदन लगा हमारा उसके बाद वो अपने मात्र से आधार पे किया कि आपने प्रोसिक्यूशन के समय एविडेंस के समय उसका कोई आक्षेप नहीं लगाया हम एक्सपर्ट से आपकी जांच नहीं
उसके बारे में क्या कहना है आपको? डिलेड आपने क्यों अप्लाई किया?
प्रोसिक्यूशन हम क्रॉस एग्जामिनेशन हर उसमें इस पर हमने तरीका किया कि क्या बात हमारी प्रीलिम एग्जाम में जहां जहां रिलेवेंट क्वेश्चन आया वहां हमने कहा कि जो मांग वार्ता उसमें मेरी आवाज नहीं दोनों आवाज मिलने अब इस बात
ये सेक्शन 45 के एप्लीकेशन में क्या रिक्वेस्ट करी थी आपने?
हमें ये रिक्वेस्ट
Where is that application?
उसमें ये रिक्वेस्ट का जांच सेंट्रल फॉरेंसिक लेबोरेटरी हैदराबाद से करा
आपका तो उसमें रिपोर्ट में क्या आया? आपकी आवाज तो नहीं आई है।
प्रॉब्लम आया कि प्रॉब्लम की आवाज हो सकती और इसमें जो सैंपल लिया वो थर्ड इन्वेस्टिगेटिंग ऑफिसर
प्रोबेबल अगर आया है तो दैट इज इन योर फेवर। अगर प्रोबेबल आया है तो आपके फेवर में है वो तो। दैट डाउट इज स्टिल देयर।
What would happen that I have not questioned it? That would not get any evidence.
You want to remove that doubt.
I want to know.
You want to make the prosecution case stronger.
I would give it, but I firmly say throughout that this voice is not mine. And the response was taken that was
Probable voice को क्या लेते हैं?
the judgment of the apex court.
उसके बेसिस पे कन्विक्शन हो सकता है। Probable voice। तो दूसरा एविडेंस अगर है कि बहुत लेट है भाई। वो तो डिफेंस का स्टेज है ना। डिफेंस में ला सकते हैं।
आपने चैलेंज किया है ड्यूरिंग स्टेटमेंट ऑफ प्रोसेस ये आवाज आपकी नहीं है। चैलेंज किस गवाह ने किया बताइए? उसके स्टेटमेंट कॉपी फाइल किया आपने? क्या कॉपी आप स्टेटमेंट फाइल किया है? P5
कैलाश कुमार गुप्ता was complaining about Para 48 days. I've thrown a suggestion.
पैरा 48
Para 48 page number 41. EW1 Kailash Kumar Gupta who is complaining.
48 is part of P5.
P5. Page number 41.
उसको क्या है 48 पे तो नहीं
कहाँ पर है 48?
पढ़िए
Para 48.
पढ़िए पैरा।
आरोपी के घर करीब इतने बजे गए थे, रुपया लेकर गया था। मैं आरोपी के घर लगभग आधा घंटा बैठा रहा, अन्य बातचीत करता रहा। यह सही है कि साथ आए आरक्षक घर के बाहर खड़ा रहा, वहां अंदर नहीं आया, तो यह कहना गलत है कि उस आवाज रिकॉर्डर में आरोपी की आवाज रिकॉर्ड नहीं है। पैरा 60
ये किसका स्टेटमेंट है?
ये कंप्लेन है।
तो आप डिफेंस में इसको क्यों नहीं प्रोड्यूस करते हैं विटनेस को?
ये एग्जाम में उनका कैसे कंप्लेंट है हमारे।
हाँ नहीं, ये जो एक्सपर्ट है जिसको आप बुलाना चाहते हैं एज DW सामने ला सकते हैं उसको। Do you want a re-examination?
Examination from the expert from the
Which is that provision on the CRPC? CR क्या है?
Depends upon different laws. We have accrued that is not executed under section 232, he shall be called upon to enter into defense or adduce evidence he may have in support thereof. If accused put any written statement, judge shall file it with the court. If accused applies for issue of any process for compelling the attendance of any witness, production of any document or a thing, judge shall issue the process unless he considers the reason to be recorded. Such application should be refused on the ground that it was made for vexatious or delay or for defeating an authority.
So that means it can be rejected under 233(3). What is the reason given in the rejection order?
Rejection से आपने 1.5 वर्ष बाद आपत्ति कर रहे हो उस पे, इसलिए throughout I am cross examination on that point मान 313 में भी हमारा स्टेटमेंट है, तो हम तो डिफेंस स्टेज पे ही हमारी बात लेके आ पाएंगे। इसके अलावा तो हमको पहले मौका नहीं मिलेगा, क्योंकि ट्रायल में ट्रायल कोर्ट के सामने हम सिर्फ सजेशन नहीं दे सकते डिफेंस के टाइम पे, जैसा भी आवाज हमारी नहीं, ये रिकॉर्ड हमारी नहीं, अब उसको प्रूव करने के लिए तो हमको डिफेंस स्टेज पे ही फाइल करना पड़ेगा। इसके पहले तो हम कर नहीं सकते। माननीय न्यायालय ने भी कंसीडर किया है इस फैक्ट को, तो जजमेंट्स में भी फेयर ट्रायल के लिए अक्यूज को अपॉर्चुनिटी दी जानी चाहिए। सप्लाई सैंपल जो भी दिया ट्रांसक्रिप्ट बनाई वो वर्बेटम जो कल्पेटिव मटेरियल उसी को रिप्रोड्यूस करके इन्वेस्टिगेशन वापस करना that cannot be done through a judgment of the court of the
Prosecuting agency on is मैं opposite side से कौन?
I have supplied property
लोकायुक्त है। उनका नाम आया है क्या? An advance copy has been supplied to Shri Abhijit Avasthi, who is not present since his name does not reflect in the cause list. Next para. Let the name of Shri Avasthi be reflected in the cause list. And the matter be posted in the next week. Next week we'll take it up. कब है डेट?
बाकी 50 लाख की नहीं वो जजमेंट में नॉट डिपार्टमेंट
फाइनल जजमेंट अभी इतना जल्दी कैसे
ये सब वो एक्चुअली क्या है यूनिट सिस्टम रहता है, जहां डिफेंस है हम उसको करने देना नहीं। इसके अलावा यदि हम करने देंगे तो जजमेंट पोस्ट कर देंगे, मान लीजिए मैटर नहीं लग पाया तो
ऑलराइट। सो we लिखिए that meanwhile as an interim measure it is directed that the trial may proceed, but the final judgment shall not be pronounced till the next date of hearing. तो लिस्ट कर देते हैं आप on 9th May.
सर्टिफाइड फॉर
Yes, certified copy. Yes, yes.
Possible matter, case number 7. Siddharth Gulati.
Next week. The fresh case. P8 is under challenge. When do you want? श्री क्या नाम है आपका? Ramesh Rai informs that the arguing counsel is on his legs before another court. Therefore, seeks a shortage. List next week.
Case number 18. Chief Pradeep Kumar Navadia.
On 18. What is the matter about? Was finally rejected or
Application for way has been filed in the termination.
on what ground?
They have decided on the present part for the full bench of the government has been filed in and it will take the one the provisional pension. Finally, for
क्या नाम आपका? Same order. Next week we'll take it.
Case number 23. Chief Sakshi Satrabal, Rice Mandiretta.
Lordship, I have gone through the judgment, Lordship, as your Lordship pointed out.
Selfie against?
Uh,
No, against what?
I have Lordship pointed out to go through the judgment which has been cited by the respondent counsel in this case, Lordship. I have gone through the judgment, Lordship, and Lordship, my case is different, though, Lordship, in that case which has been cited, it has been rejected on the ground that the defense written statement has been filed after 30 days and further period of 15 days can be extended only on exceptional circumstances. Now, the impugn order in my case may kindly be seen, Lordship, at page 11. This is not the case. It is not the case that the my written statement is rejected on the ground that it cannot be filed after 30 days. It has been, why it has been rejected? I'll just read out the order, second paragraph, Lordship. पिछली तिथि पर प्रतिवादी गण के मुख्य अधिवक्ता उपस्थित नहीं थे, फिर भी समय दिया गया, किंतु आज पुनः प्रतिवादी गण के मुख्य अधिवक्ता उठाई गई आपत्ति पर तर्क हेतु उपस्थित नहीं हुए, इस कारण अब आवेदक पक्ष की आपत्ति के प्रकाश में प्रतिवादी गण द्वारा प्रस्तुत लिखित कथन कार्रवाई से पृथक किया जाता है. Now my submission is, Lordship, they have not considered my application for continuation of delay. They have not passed any such order that holding that since it is barred by limitation or since it is not filed within 30 days, so it cannot be accepted. This is not the order. The order is because the council was not present on that day, so they have not accepted the written
No, this order is passed on the admissibility of that, or rather acceptability of the written statement, and whether it should be accepted or not accepted, looking to the fact that it was filed with great delay.
Lordship, they should have at least assigned the reason that it is not, it cannot be accepted.
No, please satisfy this court. Why should we enter into an empty formality of sending it back only for dismissal again? So please satisfy this court that you had sufficient grounds.
Lordship, my submission is I have Lordship mentioned various reasons why the written statement could not be filed.
No, but that those reasons only explain 2 years.
One
What
review
about the
application.
remaining 2 years?
One more fact I wanted to bring to your Lordship. We have also filed a review application before the tribunal, Lordship. A review of the same order which is being put to challenge before this.
That has been decided.
No, that has not been decided, Lordship. That has been deferred up to 28th of May because of the reasons of pendency of the present writ petition, Lordship. Because the tribunal was on leave from 22nd up to 26th, so I was inclined to file the petitioner was inclined to file the present writ petition. He was compelled to file the present writ petition. Now the case was listed yesterday before the tribunal, and the tribunal is directed to await the has Lordship observed that they will await the outcome of the decision of this honorable court, Lordship. The fact
You
remains,
filed
Lordship,
a review of this order 13/3/24.
Lordship, same order. But since
Then
the
if you- No, then if you want to pursue that remedy, you pursue that remedy. Don't pursue this petition. We'll give you that.
Then, Lordship, then only one the additional liberty I am seeking, Lordship. If they reject my application for review, I may be given at least 10 days time to file an appeal before final hearing of the case, Lordship. 10 days time may be granted to us after my review. They may not decide the review application and hear the argument on the same date. This is my only request, Lordship.
That we cannot presume a lot of things and then pass an order.
Lordship, because yesterday
The order passed on ifs and buts.
Lordship, yesterday the tribunal was of the opinion that they will decide my review application in the same day and they will hear the case finally on the same day. Though it is not observed on the order sheet, but the tribunal was of the opinion that the same day they will decide my review application and they will hear the case finally. So one opportunity.
No, that is your presumption. It may not happen. It should not happen like this.
Yesterday, Lordship, tribunal was of the opinion like this. They will decide both the
Something should be reflected from the order.
They have not observed in the order, but
Because we don't want to express anything on merits since you are already pursuing that review there.
then I may be granted liberty, Lordship.
Let's make that. Any objection, Mr. Manil? The learned counsel for the petitioner, after arguing for a while, raised for withdrawal of this petition to pursue the remedy of review having been filed by the petitioner to assail the order dated 13/3/24, passed in OA 1199 of 19, and which, according to the petitioner, is pending consideration before the next. This court has no manner of doubt that while considering the application for review of the petitioner, the fact of the petitioner having approached this court shall not prejudice the tribunal. With the aforesaid liberty, petition stands dismissed and Shri Mandeshita for the law.
I'm for the borrower petitioner, Lordship.
Case number 26. Insan Justice Vikram Singh.
This court hastens to add that this court has not commented on the merits of the claim of the petition and leaves it to the tribunal to take decision either way in accordance with law. Yes. 26 में क्या है? Finally. So, can it be argued today? So then it will go after the vacations. So trial is going on. This is against framing charge. क्या नाम आपका? Satyam Rai submits that the arguing counsel is not available. No, it can be argued today. You have to give some reason why he is not coming. When the case is listed, he is supposed to be here and argue the matter. On his legs before another bench. Therefore, adjournment is sought. List after these summer vacations. 27 same.
Case number 27.
Here. में बताइए चार्जशीट पेश हो गई इसमें तो चार्जशीट पेश करने को कहा No, state had a short time, but since recently charge sheet has been served, so state council had said that I want to go through the charge sheet. Have you received the charge sheet? आप बहस के लिए तैयार हैं? Not क्या नाम आपका? शोभित charge sheet. For the petitioner, submits that he is not ready with arguments on admission list after the summer vacations. Okay.
Number 29, Sunil Kumar Tiwari.
Hello?
Part of the recording here, they write that
Which order is under challenge? A2 or A1? A2.
even is there.
So how does it come as a again in a revision? Interlocutory order नहीं? Huh?
Is the interlocutory order, but it is not a getting finality of the must be challenged under forum.
When the case is taken up in Passover, no one appears for the petitioner. Next one. The challenge in this criminal revision is to an interlocutory order passed rejecting an application seeking
Voice sample of the shadow.
voice sample of the shadow.
Next problem.
Next problem. The petitioner has to first satisfy as to how this revision is maintainable in the face of bar contained in section 397, 3, 2. Hmm? Three 97 2. This next week. Thank you.
Number 31, the Sankalp Protest.
Yes.
For definition of void, because the registrar become
Who is for the prosecuting agency? Huh?
So they are seeking voice, they are seeking the power location for recording of 5%.
No, if it will take time, then we will take it up after vacation, after the lunch break.
Reply is not on record. We have only two objections that they have not implicated the person and the party on what they are.
No.
Submission, but they've already.
So then we will take it up after the lunch.
Or otherwise, we'll not do it.
Now, this is the only case now left. Yes. Any urgency?
urgency, like urgency is that anything we say is for preservation of the requirement of the quality order, identical matter, not seeking.
No, urgency means
Not.
is the trial is the trial fixed tomorrow or day after? So we'll take it up next week. Counsel for the prosecuting agency is directed to seek instruction. List in the next week. Name of it is there.